what is visualized in the preamble and what is permissible, both in Part 3 and Part 4 of the Constitution, could not be said to be violative of the basic structure or basic feature of the Constitution. In absence of any obliteration of any of the constitutional provisions and in absence of any alteration or destruction in the existing structure of equality code or the basic structure of the Constitution, neither the width test nor the identity test as propounded in Keshwanan could be said to have been violated in the amendment. Accordingly, the challenge to the constitutional validity of 103rd Amendment fails and the validity thereof is upheld. And before parting, I have expressed my views on the time span to be prescribed for the reservation policy. I have quoted the observations made by the Constitution Bench in K.C. Vasant Kumar, observations of Justice D.A. Desai, Justice Venkatramaiah, Justice Chandrachud as he then was, and also in case of Ashok Kumar. And then I said, what was envisioned by the framers of the Constitution, what was proposed by the Constitution Bench in 1985, and what was sought to be achieved on the completion of 50 years of the advent of the Constitution, that is, the policy of reservation must have a time span, has still not been achieved even till this day, that is, till the completion of 75 years of our independence. It cannot be gainsaid that the age-old caste system in India was responsible for the origination of this reservation system in the country. It was introduced to correct the historical injustice faced by the persons belonging to the SCs, STs, and other backward classes, and to provide them a level playing field to compete with the persons belonging to the forward classes. However, at the end of 75 years of our independence, we need to revisit the system of reservation in the larger interest of the society as a whole, as a step forward towards the transformative constitutionalism. Be it noted that as per Article 334 of the Constitution, the provisions of Constitution relating to the reservation of seats for SCs and STs in the House of People and in the legislative assemblies of the states would cease to have effect on the expiration of the period of 80 years from the commencement of the Constitution. The representation of Anglo-Indian community in the House of Parliament and in the legislative assemblies of the state by nomination has already ceased by virtue of 104th Amendment that is with effect from 25th January 2020. Therefore, similar timeline, if prescribed, for the special provisions in respect of the reservations and representations provided in Article 15 and 16 of the Constitution, it would be a way forward leading to an egalitarian, casteless, and classless society. Thank you so much.
I have concurred with the view taken by Honorable Justice Ravindra Bhatt in its entirety. So effectively, the decision is 3-2.
Oh.
So
immensely grateful to Allah.
we are expressing a deep gratitude for the assistance rendered by every one of you in whatever capacity as the lead counsel, as even as nodal counsel. These two counsel did excellent job. So it was a great learning experience for all of us, and this I express gratitude on behalf of all the members who are part of this bench. My colleagues also join me in expressing that. Thank you so much.
Immensely grateful.